Trial is an educational activity, first and foremost. It is a way to teach kids about the legal system, how a trial really works. So much of what they know about the way the law works is what they see on television, and that is not the way the law works. It's not whatever the popular lawyer television show is now. You try some of that stuff in a real courtroom and you're going to get bounced out on your ear. It's also teaching them critical thinking skills. It's teaching them teamwork. It's teaching them how to reach from point A to point B and reason their way through something, not just critically, but creatively. So there's some creative energies that are involved in that. And
but it's great that we all come down and intermix and learn so much about one another.
Okay, hi, my name's Jim Dean. I'm a district court judge for the last 13 years for the state of Minnesota. And I've been involved with the mock trial program both at the state and the national level. At state level for approximately 12 years and at the national level for 9 years. You know, we're not trying to make baby lawyers here or young lawyers. We aren't trying to recruit that. What we're trying to do is give them an understanding of the law. And that's what this is all about. Law affects every profession, every person, every day of their life, and it's getting more complicated. And to have more young people out there who have a basic concept of due process and other aspects of the law will be a benefit to our whole society as well as any occupation that they go into. But what impresses me is their ability at their young age to decipher the information and interpret it and come back in a pattern that frankly I don't see through practicing attorneys, older attorneys, much less students come before me. These are the top.
The whole process starts with a case committee that writes a problem for the kids to work with. And that case is designed to be as balanced as possible because they're going to play both sides of it. The teachers then take the team and they pick their team based on the interest of the kids and where they think they're going to fit the best, and they need attorneys and witnesses. At the national level, the rules require that you can have an official team of 8, only 6 may participate at one time. 3 of them will be attorneys and 3 would be witnesses, and the team that participates has to prepare both sides of the case. So if it's a civil case, they'll have a plaintiff's roster and a defense roster, and they have to know both sides inside and out. If it's criminal, it'll be the state and the defendant. And that's pretty much the nuts and bolts on it. And they work with those kids to help them develop their own theory of the case. We give them the problem. We give them the witness statements. They develop the character of those witnesses. They develop the questions they want to ask. And they develop what they think happened to create their opening and closing arguments. And they have to learn how to adjust to the other side when they get started in competition.
You prepare before coming to a mock trial competition?
Well, it's sort of, to me, it's just repetition, and you go through it as many times as possible, and first you get it so that all the information you want comes out. Then you get it so that there's no legal problems with it, like objections, no things that aren't true with the case. So once you've gotten your information out and the legal stuff out, then the final step is just to get it within time and within the mock trial rules.
The purpose for a witness, is obvious when it comes to trials, because you have to have people that bring forth the evidence for the case. But I think one of the most important things, and I think something that needs to be done with the witnesses, is to make not only them be for the purpose of giving testimony, but to be entertainment. And that's what I think a lot of what we try and do as a team is make the witnesses entertaining. Yeah, he does that real well.
Can you please describe Jumbo Amusements to the jury?
Oh, yes, Jumbo Amusements. J-U-M-B-O. I'm talking about jumping, unique, mind-blowing, ooh-wee. Jumbo Amusement was a great part. I'm talking about you could not refuse to be amused.
Another purpose of the witness is that we try to portray the witnesses actually going through what they're talking about and actually, really know what happened and how it happened and why it happened and things like that. So we get a background of the character and we try to develop that character as, actually being the person that went through the experience.
Where I would then go just check the fence over in the northeast corner of the park, make sure no one was tampering with the fence. The other demolition crew entrance, the other corner of the park, make sure the
You're really bound to your affidavit. Any extrapolations you make from that have to be reasonable. But in this case, when he's going for entertainment value, little things like he says he was in his affidavit. He says he gets woken up one night. He makes an extrapolation that he was watching the Late Show. And
Like, yeah, any extrapolations you make sure they don't materially affect the case.
If it affects the case, you cannot say something like that. But you'll find teams where the witnesses are just sort of
stiff. They're stiff. No, to be honest, because the thing about in any situation, regardless of mock trial or anything, is that people listen to you more when you get them on a personal level.
My name is Francis Thurmond. Folks call me Fritzy.
And when you can create a character that you can feel that can become personalized with the jurors, instead of just going up there and saying, my name is Leslie Cooper, I live in, Myrtle Beach, South Carolina, my wife died on the Flying Tiger, you could say, she was such a beautiful girl.
Exactly.
It's so tragic to lose someone like that. Well, we do rehearsals, but I think that is like secondary when you're a witness, because I feel that the two most important things about being a witness in mock trial is knowing your affidavit front to back, and knowing what your character, who your character is, what he is, what she is, so you can, what the limits are with the character. So, because I think what a lot of teams do is that if they attempt to create a character, when they just go and they're like, oh, so they'd probably, have a smile and they'd talk like this every time they answer the question. But then they're getting so canned responses because they don't really know what the character is, that when they get proposed with the cross-examination, they break out of character.
You better learn to improvise.
And you have to be able to maintain your character and know what your character would say.
My first witness in the first trial, Robin Rutledge. Who did we play our first trial?
Louisiana. That was in the courtroom where we had the judge, Jesse Ventura.
Okay, yes. We started off with a judge who was very pleased to be from Minnesota.
I'm Judge Dean from Minnesota, where I have the only action figure for a governor. I mean, we have a governor who has an action figure, Governor Jesse Ventura.
And we want to thank you for coming to South Carolina for our mock trial championship. Thank you.
Well, the trial started off, I usually survey the team, and I can tell if we're going to win or not, and we win that trial. So, it came that Robin, Willie he played the character Robin Rutledge. Very emotional. His testimony was very emotional. You could get attached to it very easily and really believe what he's saying. I came up next. I played the doctor. I think I was on command. I think I had all my words and all my grammar was on point. And I did do a little bit of arguing in the cross, and that was addressed to me, and I changed that up.
This is the best information I can give you, and we can't obviously tell you who won, who didn't win. You'll find that out at the end. But the best advice I can give you, and I've been sitting here almost the longest of any of the judges in there, is that for your witnesses, your attorneys have done an excellent job. Your witnesses are very good. But don't argue with the other attorney. Don't consider any doors open so that you can argue and add to an answer. If a question calls for yes or no answer, your witnesses are much better served by just answering it yes. You have a very strong team, and this information, if you use it wisely, will
in the first trial, I came in with speculations as to the quality of our plaintiff side coming into nationals, but we dominated the first trial. And I was very pleased to see how dominating we were. We were very composed. And we, in my mind, I think so far as to all three trials that we have dominated.
The second trial was
Hawaii.
Yeah, we scrimmaged those guys prior to that trial. We went against their defense side.
It was frustrating.
Yeah, it was kind of frustrating because, their coach, he was presiding over the trial. So, we didn't agree with a lot of things, but once we got into the actual competition, we went against their defense team, and
We went against their
the plaintiff side. We went against their plaintiff side, and while I was sitting there, I became a little annoyed. I did survey once again our competition. We won again, and so I think I kind of blame myself. I think I kind of lost my composure because I was kind of really annoyed with their arguments and stuff. But we fought through that because you got to go through that stuff. And we fought it out, and here we are with one trial to go.
Luckily my composure the entire time would be Morrison.
So he had to
So being angry, I I don't think it lost anything. But yeah, in the trial, nice kids outside of court.
Yeah.
But I felt that some of the objections they were making were a bit ridiculous.
Like to be seated, please. My name is Richard Shuning. I will be the presiding judge this afternoon in this case.
Good afternoon, Your Honor, members of the jury. My name is Ryan Guzzo-Purcell, and my co-counsel and I represent the defendant, Mr. Francis Thurmond. Today I will be conducting the direct examination of Mr. Thurmond, the cross-examination of Dr. Kildare, and giving the closing argument. My co-counsel will now introduce themselves.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Caitlin Steitzer, and I will be giving the opening statement for this case, as well as conducting the direct examination of Joe Jackson and the cross-examination of Robin Rutledge.
Good morning. My name is Anna Sarah Guzzo-Purcell. Today I will be conducting the direct examination of Marion Morrison and the cross-examination of Leslie Cooper. Our witnesses will now introduce themselves according to the order of their appearance.
My name is Joshua Field. I'll be playing the role of Francis Thurmond, the defendant in this case.
Good morning, Your Honor, members of the jury. My name is Josh Seidel, and I'll be playing the role of Joe Jackson, the security guard at Jumbo Amusements.
Good afternoon. My name is William Linke, and I'll be playing the role of Marion Morrison.
We're here tonight because of a horrible accident that resulted in someone's death. And you're going to hear tonight that that accident could have been easily prevented if the defendant had just taken the necessary precautions. And tonight you're also going to hear two exactly opposite sides to the same story. Someone is lying. And it's going to be your duty to decide who is telling the truth.
Every day, we put our lives in the hands of complete strangers. Now, when we cross the street at a crosswalk, we expect the cars to stop. They have a responsibility to stop. But we too have a responsibility. We cannot just jump out in the middle of the freeway and hope that the cars can stop before they hit us. They may slam on the brakes. They may take every reasonable step to avoid hitting us. But if we knowingly take that risk, we cannot blame them if they do. At some point, we must take responsibility for ourselves.
What do you do for a living?
But I used to work for Jumbo Amusements.
For how long were you employed at Jumbo Amusements?
Oh, I've worked there for over 50 years now, since 1947 to 1997.
So during your 50 years of experience at Jumbo Amusements, what kinds of positions have you held?
Well, I started off at Jumbo Amusements as a snack bar attendant until I was promoted to manager of the snack bar. I was moved to the ticket sales booth after that, and my last position at Jumbo Amusements was working night shift as a security. Kids just always have this special talent to just make trouble no matter what's in their way.
I'm asking you, it wasn't possible for a secret society to be meeting on this roller coaster while it was open.
You see now, the kids, they can get themselves into a lot of trouble, and they don't care what's in there.
I object to
Mr. Cooper, if you will answer the question.
Well, kids can always find a way to do whatever they want. Nothing's going to stop them.
Offense that exceeded building code and the security guard. How long were they in place?
Well, they were in place from the day I closed the park each and every day until the Flying Tiger was taken down.
Were they still in place the night that Tom Calhoun was killed?
Yes, they were.
And at any time was your park left unattended?
No, someone was in the park at all times, whether it be my security guards or...
Referring back to the map, could you please show us the thorough rounds that you did at the beginning and end of your shift?
You gonna stand up again? That's okay.
You may.
Now, may I also move in?
You may.
And before, I'd start here at the first clock, and then I would go over to the demolition crew entrance where they bring their equipment in, where I would simply check the fence, go to the clock 3, which is right behind the movie theater, then go over to the other guard kiosk, where I would then go just check the fence over in the northeast corner of the park, make sure no one was tampering with the fence, the other demolition crew entrance, the other corner of the park, make sure the fence wasn't tampered with, to the Flying Tiger, to the dance hall, the ticket booth, and I returned to the original.
Tom Calhoun's death was a senseless tragedy. The last thing that anyone wants to believe is that Tom's actions caused this tragedy. It shouldn't be his legacy. That's why Fritzie Thurmond is on trial today. Because it's easier to blame an adult than to hold Tom accountable. But we have proved today that Fritzie was responsible for safety in his park, while Tom utterly failed to take responsibility for his actions.
If Thurmond had secured his park, it wouldn't have been so easy to get in. Mary Calhoun will never see her son again. There will always be that empty place at the dinner table, a constant reminder that her son is gone. She will never see him graduate or get married. And the only time she'll ever see him smile again is by looking at that faded picture on the mantle. If Thurmond hadn't been negligent, Tom still would have been here today. He should have secured the fences. The fences were down. No lights, one guard.
I'm totally amazed and astounded how well young people do that's in this mock court type competition. And y'all didn't let me down one bit today. You were all fantastic. And I say this, and I don't say it lightly. I've been a lawyer, practiced law about 18, 19 years, and been a judge about 5 years, it'll be 6 years in July. And I honestly would put some of you up in front of some of the lawyers that come in my courtroom on a regular basis.
The third trial, which we have
just finished
about 15 minutes ago, 30 minutes ago. It doesn't matter. We won anyway. Yeah, that trial there, we came into the courtroom there, sat down, surveyed again. And I felt very, very confident after our opening statement. I thought, I was kind of worried about, our attorneys are on the plaintiff's side, but once again, just like the first trial, we dominated. And I think, our confidence is really getting stronger and stronger.
It pointed out to me later that being Robin Rutledge, who had his best friend killed and is reliving it through his testimony, that their counsel, their attorney, was being rather
obnoxious,
rather curt in my face for my character. And it was pointed out to me that she did indeed look rather poorly for being that strong to a character like that. That you might want to make your points on your cross-examination, but a little more.
I for my cross-examination today decided really not to argue at all. Because what you can do instead of argue is use what they said, add a couple more words to the end of it, and you haven't argued with them. You've just, stated. It's like when they asked me today as Leslie Cooper that you never saw Tom Calhoun, he's the kid who died, in the park that night. And I responded with, you're right. I don't know if he was one of the kids who was in the park that night. Which isn't really, which is not an argument at all. It's a complete agreement. You just happen to add on a little attachment.
And she's only caught the part that you've agreed with her, that she doesn't object to
non-responsive
respect.
And I think I have realized that we have right now 5 best attorneys in the nation on our side. And that's what makes me feel confident, is because I know that if I do slip up, that they'll be there to save me.
My name is Timothy Fitzpatrick, and along with my co-counsels James Tiang and Daniel Rigby, we represent the mother of the deceased Tom, Mary Calhoun. We understand that we cannot put a price tag on the life of a young boy. But South Carolina law allows Mrs. Calhoun to seek compensation for her losses. But before she can be awarded compensation, you, the jury, and we, the plaintiff, must prove that Francis Thurmond was negligent, Francis Thurmond being the proprietor of General Amusements, and that his negligence was a proximate cause of Tom's death.
Evidence will show that while Francis Thurmond took every reasonable step to secure his park, Tom Calhoun was determined to evade these precautions and acted in reckless disregard. Moving on, when you got to the park that night, Morrison was supposed to be there for your initiation, correct?
Yes,
And you had seen his van parked outside the park.
that's correct.
This was the same Morrison who said he would make Tom pay. Isn't that true?
That was a while earlier, yes.
And you could not find Morrison anywhere.
We didn't know exactly where he was.
But you decided to climb this roller coaster anyways. Isn't that true?
Thurmond.
So then, you don't know if the park you say kids were sneaking into when you were in high school had any of the same security systems as the park that exists today, do you?
No, I do not. Jumbo Amusement was a great park. I'm talking about you could not refuse to be amused. We had Flying Tiger, games, arcades, theaters. Just a place where you enjoy yourself.
George, the quick rounds like you did every other hour.
Oh, yes, ma'am. Now, when I say quick, I do not mean that I was any less perceptive on these rounds. All it means is that at one point in time, I had more visibility.
So we've had 3 trials now over the course of 2 days, and we're going on our 4th and last before the championship round.
Yeah.
We've competed very well, and I think Washington should hopefully be in the final round.
Definitely, Josh.
Yeah, it's like he said, we worked really hard up to this point. Our confidence is getting better and better with each trial.
We've had our 3 trials, and I think we've performed better than any other team who has done this trial, regardless of whether we were going up against them or not. I think I've had a great time here, and I feel confident that we will be going into this next trial undefeated, and we'll be going out of this competition undefeated.
It's too hot in South Carolina.
Oh, it's way too hot, man. They need to get a big old air conditioner over this entire state.
We've gone through 3 trials, and we're not given any scores until after our 4th trial. That's when actually even then, we don't find out our place until the banquet tonight, and we don't find out actual scores until well after that. So it's pretty much you're guessing as to how well you've done. I think our team has done incredible. We've performed as well as I've ever seen in my 3 years, better than ever. And I think we're 3-0 right now. We have 1 trial remaining in the normal tournament, and then if we're one of the top 2 teams, we'll have a championship trial this afternoon that will decide the national championship.
This is one of the millions of speculative conversations that we have concerning mock trial.
I think she's what's going on right now? What are you guys waiting for?
We're waiting for them to announce who's in the final round, whether it's us or not. But by the way, we have many speculative conversations. Yeah, we're
Deciding whether this morning's trial screwed us over or not. But we've decided that the last group we went against, we were better than them.
They were really good.
They were really good. And so therefore, since we're going against a really good team,
we're hoping.
That would mean that
we won the third.
That we won that 3rd trial.
Yeah, but we're going to find out any minute now whether or not.
Moment of truth is here. We've got our messenger running through the crowd.
All right, and the envelope, please. You could care less who I am, so I'm just going to rip this open and give you the results. Hey, my feelings aren't even hurt, okay?
Good job.
Wow. All right, I have my bulletproof vest on, everybody. The final round, which will commence in just a few minutes up at Richland County Courthouse 2A, Courtroom 2A, is North Carolina and Washington.
I felt it was better to have loyalty to my home tournament.
Okay, now button the rest of it. Put this on your waistband, and then you kind of want to do something to this to happen.
Ladies and gentlemen, and we're here for the national final competition between the Washington team and the North Carolina team. As you know, this is Judge Mark Westbrook who will be presiding in the trial, and he's going to gamble a little bit. He's going to flip a coin for the seedings to see who's plaintiff and who's defendant.
Okay, now I will tell you, I do not know which is Washington or North Carolina. Okay. I'll flip the coin. If it's heads, J.H. is plaintiff. If it's tails, J.H. is defendant. Are we ready? Yes. Okay, we'll flip. It is tails, J.H. is defendant, J.P. is plaintiff. Go ahead and get to your tables and get prepared, and we'll be in a few minutes.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Katrina Miller, and my co-counsel and I represent the plaintiff in today's case. Now, today I will be conducting the direct examination of Leslie Cooper, the cross-examination of Francis Thurmond, as well as giving the closing argument. My co-counsel will now introduce themselves.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Helea DeBarros. Today I will be giving the opening statement, as well as conducting the direct examination of Robin Rutledge, the cross-examination of Marion Morrison, and that is it.
Good afternoon. My name is Anna Sarah Guzzo-Purcell. Today I will be conducting the direct examination of Dr. Welby Kildare, as well as cross-examining Joe Jackson. Our witnesses will now introduce themselves according to the order of their appearance.
Good afternoon. My name is William Lemke, and I'll be playing the part of Robin Rutledge.
Good afternoon. My name is Joshua Fields, and I'll be playing the role of Dr. Welby Kildare.
Good afternoon, my name is Josh Seidel, and I will be playing the role of Leslie Cooper, a former employee of Jumbo Amusements.
Defense, would you now introduce yourselves in the same fashion, please?
Yes, Your Honor. Good evening. My name is Ann Clark, and my co-counsel and I represent Ms. Frances Thurmond individually and doing business as Jumbo Amusements. Today I will be doing the direct examination of Mr. Joe Jackson, the cross-examination of Mr. Leslie Cooper, and the closing argument.
Good afternoon, Your Honor. My name is Luke Lingle. I will be doing the direct examination of Mr. Marion Morrison and the cross-examination of Dr. Welby Kildare.
Good afternoon, Your Honor. My name is Jonathan Haywood. I'll be doing the cross-examination of Robin Rutledge, the direct examination of Ms. Frances Thurmond, and I will also be giving the opening statement. If Your Honor, please, these are our witnesses. This is Ms. Sarah Pupalis playing the role of Frances Thurmond. This is Mr. Thomas Croshaw playing the role of Joe Jackson. And then this is Mr. Sean Maroney playing the role of Marion Morrison.
Tom Calhoun died on Halloween night, 1998, when he fell from the Flying Tiger roller coaster in Jumbo Amusements. He was there because park owner Frances Thurmond promoted a ghost story that she knew lured teenagers to her park. He died because Thurmond failed to secure her park after it closed in 1997. Now today the plaintiff will prove three things. First, that Tom Calhoun fell from the Flying Tiger in Jumbo Amusements. Second, that park owner Frances Thurmond knew teenagers were likely to climb her roller coaster on Halloween because they had on previous Halloweens. And third, that after her park closed in 1997, Thurmond's failure to either dismantle the Flying Tiger before Halloween 1998 or to properly secure it on that night was negligent and caused Tom's death. Now first, Tom fell from the Flying Tiger. Robin Rutledge, Tom's friend who was with him on Halloween 1998, will tell you that they went to the park that night around 11:30 p.m. He will also tell you that they drove directly past the one security guard on duty who did not notice them because he was talking to another person, and then easily laid down the fence near the Flying Tiger. They then, at around midnight, began to climb the roller coaster, at which time Tom fell. Now, Leslie Cooper, a former employee of Jumbo Amusements, will corroborate Robin's testimony. He will tell you that he was also at the park that night from approximately 11 p.m. to 12:15 a.m. and spoke with the security guard. He will also tell you that he heard voices coming from the Flying Tiger around midnight and that he saw a section of the fence laid down near the Flying Tiger, just as Robin will describe. Now, second, Thurmond knew teenagers had climbed a roller coaster on Halloween. For years, a secret society at Riley High had held their annual initiation at the Flying Tiger on Halloween. This initiation involved climbing the Flying Tiger to see the ghost of Ashley. Ashley was a young newlywed who had fallen from the coaster in 1946, and as legend tells it, her ghost appears there every Halloween at exactly midnight. Now, the evidence will clearly show that when Thurmond herself was a member of this society in high school, a girl fell from the coaster and broke her leg. Leslie Cooper will also testify that she told Thurmond on numerous occasions that teenagers were climbing her roller coaster. Yet Thurmond decided to ignore these signs and instead began to promote the very story which lured teenagers to her park. In the late 80s, Thurmond began holding a midnight roller coaster ride on the Flying Tiger, exploiting Ashley's story. Every year, she held this roller coaster and teenagers were lured to the park. Now, on Halloween night, 3rd, Thurmond was negligent. After her park closed in 97, Thurmond dismantled her park. By Halloween 1998, all rides had been taken down, except the Flying Tiger. It still towered above the remainder of the park, waiting for teenagers to climb it, as they had done so many Halloweens before. On Halloween night, the one night that Thurmond knew teenagers would be at her park, she had one security guard there. One security guard who she herself called Clueless Joe Jackson. The evidence will show that Thurmond never told Jackson to watch the Flying Tiger on Halloween. She never said the teenagers might try and climb the coaster at midnight, because they had before, and for the past 8 years she had been promoting the very ghost story that lured them there. Now, Thurmond had a great marketing idea. She promoted a story that she knew teenagers would enjoy. She had enjoyed the same story when she was a teenager. But she failed to protect her park from a danger that her roller coaster posed to those teenagers. Now, yes, Tom had a drink before he came to the park that night. But at the end of today's trial, it will be clear that any negligence Tom has was clearly outweighed by Thurmond's neglect to secure her park on the one day and during the 1 hour that she knew she had to. And that is why at the conclusion of today's trial, we will ask that you find Frances Thurmond liable for the death of Tom Calhoun. Thank you.
May it please the court, counsel, members of the jury, choices. We all face choices and decisions we must make every day. And with these choices, there comes a consequence. On October 31st, 1998, Tom Calhoun made several poor choices. And with these poor choices came very severe and tragic consequences. The evidence will show that Tom Calhoun's poor choices and the consequences that followed are the only reasons why we're here today. Good evening. My name is John Haywood, and along with Luke Lingle and Ann Clark, I represent Miss Frances Thurmond, the former owner of Jumbo Amusements. Now, ladies and gentlemen of the jury, we ask as you listen to the evidence today, you keep two things in mind. First, that it is the plaintiff who bears to prove by preponderance of the evidence that this incident occurred at Jumbo Amusements, that Miss Frances Thurmond was negligent, and her negligence caused Tom Calhoun's death. Secondly, while we all feel sympathy for the plaintiff at the loss of her son's life, your decision today cannot be based on sympathy. It must be based on fact. Now, the evidence you will hear today will require you to grapple with several questions, the first of which is whether or not this incident even occurred at Jumbo Amusements. Now, Mr. Robin Rutledge will tell you that according to his story, Tom was climbing on the Flying Tiger roller coaster and fell from a height of approximately 60 feet. However, Dr. Welbert Kildare, the doctor who treated Tom Calhoun in the emergency room, will tell you that Tom's injuries were only consistent with a fall from 20 to 40 feet. Marion Morrison will then tell you how he came upon Mr. Calhoun after he fell from the third-story balcony at the Sand Trap condos after a party there that evening. The only other evidence that the plaintiff will offer that this even occurred at Jumbo Amusements is the testimony of Leslie Cooper, a former disgruntled employee who has held a grudge against the park ever since his wife died there 50 years ago. Now, we anticipate that Mr. Cooper will tell you he went to the park that evening to visit with his dead wife's ghost, and that he found a section of fence and a hat with the letters RHS on it. However, Mr. Cooper will also tell you that he did not see anyone in the park that night other than Mr. Joe Jackson. Joe Jackson, who was the security guard on duty that night, would tell you how he denied Mr. Cooper entry into the park and that Tom Calhoun was not injured in Jumbo Amusements. Now, the second issue of which you might have to decide is whether Miss Frances Thurmond was negligent. Now, the plaintiffs contend that Miss Thurmond was negligent in failing to properly secure her park. However, the evidence will show that Miss Thurmond went the extra mile to secure her park. Listen as she tells you that she ordered the installation of an 8-foot fence, which actually exceeds building code requirements. She also hired a security guard from Crime Control Incorporated, the most respected security company in town. The third issue of which you might have to decide is whether Mr. Tom Calhoun was also negligent. Robin Rutledge will tell you that on that evening, even if you believe his story, he and Tom while Tom was climbing the roller coaster, he was acting carefree and confident. Dr. Welby Kildare will tell you that at the time he fell from that roller coaster, Tom Calhoun had a blood alcohol level of 0.09. Finally, you will have to decide who is more at fault, Miss Frances Thurmond, who went the extra mile to secure her park, or Mr. Tom Calhoun, who was participating in an illegal activity while intoxicated. Now, we anticipate that the plaintiffs will try many things to make you forget the facts of this case. They'll try to fill the holes in their case with ghost stories and urban legends. However, we're sure that after you hear the evidence, you will know that those stories are merely ghost stories. In short, the evidence will show that this incident did not occur at Jumbo Amusements, that Miss Frances Thurmond was not negligent, and sadly, Tom Calhoun, and only Tom Calhoun, was responsible for his own injuries. Yes, we are all saddened over the loss of this young boy. However, Tom Calhoun did not fall victim to a roller coaster. He fell victim to his own choices. Thank you.
Yes, I go to Riley High School.
Did you know the deceased, Tom Calhoun?
Tom was my very best friend.
When did you first meet Tom?
Tom was a new student at Riley High School last year. He was just really fun and outgoing and a really nice guy, so we hit it off pretty much from the bat.
Did you and Tom share any of the same hobbies?
Tom was an amazing musician. I mean, he could really play guitar, so he started this band with me called the Outcasts. It was great. I mean, he even got Ted McCain from the Sliding Doors to play for us.
I fail to see how any band in which Tom Calhoun was in is relevant to the matter at hand, whether Miss Frances Thurmond was negligent.
Your Honor, this goes to the relationship between Mr. Tom Calhoun and Robin Rutledge.
Overruled. Thank you, Your Honor.
Did you and Tom share any of the...
Now, Mr. Rutledge, you and Tom were good friends, weren't you?
He was my best friend. He was a great guy.
And as you just said, he was your best friend, isn't that correct?
Yeah.
And on direct examination, you stated you liked Tom because he was always doing something wild and crazy, isn't that right?
Objection, Your Honor. This is an improper character testimony under Rule 404A.
If Your Honor, please, I believe he has testified to these facts on direct examination, and therefore I'm merely probing these, Your Honor.
What was the question again?
In fact, you stated you liked Tom because he was always doing something wild and crazy, isn't that correct?
He was a pretty fun guy, yeah.
Please introduce yourself to the jury.
My name is Dr. Welby Kildare. I'm a physician, board certified in emergency medicine. I practice at Myrtle Beach General Hospital.
Where did you receive your education in medicine?
Oh, I received my education in medicine. I got my BS in biology from Thurmond University. Then went on to get my PhD in physiology from the University of South Carolina. And from there, I got my MD from the University of South Carolina School of Medicine.
Could you please briefly describe your professional background to the jury?
Yes. I did a residency at Duke University, specializing in emergency medicine. Then I worked at Johns Hopkins for about 10 years before returning to Myrtle Beach.
Have you ever been published on the subject of medicine?
Yes, I've written articles in the New England Journal of Medicine, as well as the Journal of the American Medical Association, also known as JAMA, and these articles focused on emergency medicine and fall-related injuries.
At this time, I ask that the doctor be admitted as an expert in the areas of emergency medicine and fall-related injuries.
Is there any objection?
Dr. Kildare, you're testifying as an expert witness today, aren't you?
Yes, sir. Yes, sir.
And unlike most expert witnesses, you aren't being paid, are you?
No, I'm not, sir. No, I'm not, sir. This is a personal thing I want to be addressed.
In fact, Dr. Kildare, you're here because you believe that amusement parks, such as Jumbo Amusements, are health risks. Isn't that correct?
Yes, sir. Yes,
In fact, Dr. Kildare, like you stated on your direct examination, you go to many high schools and speak of these roller coasters. Isn't that correct?
yes, yes, sir, that's
In
correct.
fact, you've gone to Riley High School. Isn't that correct?
Yes, that's correct as well.
And you understand after today that Mr. Tom Calhoun attended Riley High School. Isn't that correct?
Yes, sir.
And you stated that you give these lectures because you want to see young people make good choices. Isn't that correct?
Yes, sir, that's why it's addressed to adults, students, you know. So the word is out on it.
And you also stated that young people, they drive too fast, they drink too much.
I object. This is an improper opinion.
Would you please introduce yourself to the jury?
Good afternoon. My name is Leslie Cooper.
Where do
I
you
live
currently
here in Myrtle Beach, South Carolina.
How long have you lived in Myrtle Beach?
I lived here about 50 years now. Moved here in 46. I was just 19 then.
Are you currently employed?
Oh, no, ma'am. I was asked into early retirement from my last job. I was fired.
Objection, Your Honor. Relevancy. The witness has not said where he was employed or at what point in time his employment was. I fail to see how this is relevant to today's case.
May I respond, Your Honor?
The objection's overruled.
Thank you, Your Honor.
Certainly you can go into it on cross if you need to.
Good evening, Mr. Cooper. My name's Ann Clark. I just have a few questions for you tonight.
All right.
Now, Mr. Cooper, you never knew Tom Calhoun, did you?
Oh, no, ma'am.
You've never seen him before in your life, as far as you know. Isn't that correct?
No, ma'am, never seen him.
And Mr. Cooper, you don't know where Tom Calhoun was on the night of October 31st, 1998, do you?
I don't know if he was one of the kids in the park that night, ma'am.
You don't know if any kids were in the park that night because you never saw anyone other than Joe Jackson. Isn't that correct?
Well, I heard people, ma'am.
But you don't know who you heard, do you?
Like I said, I don't know if Tom was in the park that night. I don't know if he was one of the people I heard.
Please state your name for the record.
My name is Joe Jackson.
And how are you employed?
I'm a security guard for Crime Control Incorporated, or CCI, in Myrtle Beach, South Carolina.
Mr. Jackson, prior to working for CCI, what, if any, other positions have you held in the security field?
Well, I worked my way up to the Chief of Security at the Midlands Institute of Tonsilology before I retired and began working for CCI.
And how long have you been working for CCI now?
It's been right at about 9 years now.
What are your present job duties at CCI?
It's my job to provide on-site security services for the clients of CCI. I keep the places of CCI's clients safe, and I keep people out of it.
You wanted to work your way up to be one of the private investigators that works for CCI?
Yes, it's every person's natural ambition to try to advance.
But in the 9 years you've worked for the company, you never received that promotion?
Objection, Your Honor. Relevancy. The witness is merely here to testify as to his observations on October 31st, 1998. Any job ambitions or promotions he may have had are irrelevant to his security on October 31st, 1998 at Jumbo Amusements.
Thank you. In the 9 years you've worked for the company, you never received that promotion?
Well, no, I didn't get the chance because all these youngins kept coming into the coming on to CCI, and they were taking those jobs.
And those youngins who did take those jobs refer to you as clueless Joe Jackson, don't they?
Objection, Your Honor.
Please state your name for the record.
Marion Morrison.
And how old are you?
I'm 16.
Where do you live?
I live in Saugastee, South Carolina, in Horry County.
Marion, do you attend school?
Yes, sir. I'm a junior at Riley High School.
Did you know Mr. Tom Calhoun?
Yes, sir. I knew Tom.
How did you meet Mr. Calhoun?
He came to my school at the beginning of our sophomore year.
And did you and Mr. Calhoun share any of the same interests?
I guess so. We were both in our own bands.
Did this cause any friction between the two of you?
No, sir, not at all. He was in his band and I was in mine. It actually worked out that way, too, because he took a drummer off my hands one time.
Could you please describe your relationship with Mr. Calhoun?
Well, I'm not sure you'd call it much relationship. We were just classmates. We never really hung out together outside of school.
Now, Ms. Morrison, I'm just going to ask you a few questions. Tom Calhoun.
Please, before counsel.
Oh, pardon me. I'm so
Thank you, Your
sorry.
Honor.
Is that better? Yeah.
Tom Calhoun came to Riley High at the beginning of your sophomore year,
Yes, ma'am.
and he was always trying to impress you,
He was always pulling stunts trying to impress us. Yes, ma'am.
always acting like he was really bad or something.
Yes, ma'am. He was always trying to do crazy stuff, dangerous stuff.
But you didn't really like Tom, did you?
Yes, ma'am, that's correct, because I didn't like the way he was always pushing for us to do dangerous stuff that we just didn't want to do.
Objection, Your Honor. This is an improper character testimony under Rule 404A as to whether Tom was always doing dangerous things.
Please state your name for the record.
My name is Frances Thurmond, but people call me Fritzy.
Are you currently employed?
No, sir, I'm not.
Which was the last job that you held?
Well, I was responsible for the day-to-day management and operation of Jumbo Amusements. It's an amusement park that was in Myrtle Beach from 1985 until 1997.
And who was your employer?
Well, I was employed by my father, Mr. Harlan Thurmond, until he died. And when he died in 1991, I inherited the park and became its sole owner.
Now, you previously stated you were employed there until 1997. What happened in 97?
Well, unfortunately, we had to close the park in that year.
Good afternoon.
Good afternoon.
You know dismantling a roller coaster can be dangerous.
Yes, and that's why we took adequate precautions in securing our park.
That's why you hired Joe Jackson from Crime Control Incorporated.
Yes, like I was saying, we hired Mr. Jackson to come and work from 7 p.m. to 7 a.m., and we installed a fence.
And you entrusted him with the safety of your park.
Yes, ma'am, I did. He was from
the
Crime
guard you
Control
hired-
Objection,
Incorporated.
Your Honor. I ask that the witness be allowed to explain her answer.
Your Honor, may I respond?
Well, you don't need to. She may explain her answer, but let's be a little more brief about the explanations, okay?
Yes, sir.
Thank you, Your
Go
Honor.
ahead.
Mr. Jackson was entrusted with the care of the park because he came from a very well-respected organization of security guards.
Now, the guard you hired prior to Joe Jackson, that was Leslie Cooper. On Halloween night of 1998, Mary Calhoun lost his son. Robin Rutledge lost a best friend. And the city of Myrtle Beach lost an outgoing teenager. And that teenager is gone because of Frances Thurmond's negligence. But maybe 50 years from now, someone will use the legend of Tom Calhoun's ghost to revive a dying business. Even Frances Thurmond admits that ghost stories are good for business. Frances Thurmond promoted a ghost story. She profited from it, but she didn't protect people from the danger that story presented. At the beginning of this trial today, we told you that we would prove 3 things. First, that Tom Calhoun died as a result of a fall from the flying tiger. Second, that Frances Thurmond was negligent because she knew such accidents had been occurring, and she failed to properly secure her roller coaster or dismantle. And third, that her failure to do these things was the proximate cause of Tom's death. First, all the evidence presented today clearly points to a fall from the flying tiger. 3 witnesses, Robin Rutledge, Dr. Welby Kildare, and Leslie Cooper, have all told you the same story. Robin told you that when he and Tom went to the amusement park, they saw the guard talking to someone at about 11:30. Leslie Cooper testified that he himself was talking to Joe Jackson at about 11:30. How could Robin and Tom have seen the guard talking to someone if they weren't at the park that night? They were at the park. That's why Leslie Cooper heard a horrible scream. That's why he found a section of fence that looked like it had been driven over. Robin's story. Now, at the beginning of this trial, defense counsel told you about choices. Frances Thurmond made choices. Tom Calhoun was the teenager. Frances Thurmond was the adult. She chose not to properly secure her park. She chose not to tell Joe Jackson, her own security guard, that she'd been advertising a roller coaster ghost to appear on Halloween for over 10 years. She knew that story lured people to her park, but she didn't do anything about it. She knew that people had been climbing it in the past, and she knew that from her own experience. That park lured teenagers. That roller coaster ghost lured teenagers. It lured Frances Thurmond as well. Dr. Welby Kildare and Leslie Cooper have both testified that Frances Thurmond was a part of that secret society that lured kids to the Flying Tiger and then tried to scare them into falling. One year, Frances Thurmond even scared a kid so bad that she fell and broke her leg. She knew the ghost story was dangerous. She knew the Flying Tiger was dangerous, and she didn't do anything about it. Her one security guard was at the opposite end of the park when the roller coaster ghost was supposed to appear. These are not reasonable actions. Ladies and gentlemen, when you have a roller coaster, there's often a sign by it. Maybe it has a dwarf on it. The dwarf that says, you must be this tall to ride the ride. But if someone rides your ride and then falls and is hurt, it's not enough to say, I had a sign. They should have known. There has to be someone there to say, no, you can be irresponsible, you can be reckless, and that's dangerous. I want you to stay away from things that can hurt you. Frances Thurmond knew the danger. She didn't do anything about it. That's why we ask that you find her liable. Thank you.
May it please the court, counsel, members of the jury, Tom Calhoun did not fall victim to a roller coaster. He fell victim to his own choices. As tragic as the events of October 31st, 1998 were, you and I know, and presumably Tom Calhoun knew, the unforgiving age-old adage that if you play with fire, you're going to get burned. Members of the jury, we acknowledge how difficult your role in this case is. However, in just a moment, the court will instruct you that you are to set aside any natural sympathies you may feel for Tom Calhoun and his family and ground your verdict solely on the evidence. In determining your verdict today, you will be called upon to answer 3 issues. The court will tell you that the plaintiff bears the burden of proof by a preponderance of the evidence as to the first 2 issues. Now, turning to the first issue, whether the decedent was injured at Jumbo Amusements on Halloween '98, or whether, as the only credible evidence supports, he fell from a balcony at the Sandtrap condos. What do we know? Now, let's look at the plaintiff's witnesses. What other than the self-serving testimony of Robin Rutledge places Tom Calhoun at Jumbo Amusements on October 31st, 1998? Who other than Rutledge stands to gain from concocting a story to divert people's attention from what he and the decedent were doing on the balcony that night? Compare Robin's story to the testimony of Dr. Kildare. Robin told you that the decedent was nearing the top of a 90-foot roller coaster when he fell. However, Dr. Kildare testified that under his expert opinion, the decedent's fall in all probability was from a height of only 20 to 40 feet. That's a 50-foot difference of opinion. Now, Marion Morrison told you that the decedent fell from a 3rd-story balcony while drinking at a party, testimony consistent with the doctor's expert opinion. Marion also told us that when he came upon Robin and the decedent under the balcony that evening, Robin was in hysterics, fearing he would be found out for drinking and smoking. Mr. Joe Jackson told us that during the whole night of October 31st, 1998, no one came into the park except for Mr. Leslie Cooper, or attempted to come into the park. And as to Leslie Cooper, even if you believe a disgruntled former employee who sees his dead wife's ghost, the only thing he heard that night were screams, and he never saw Tom Calhoun or anyone else in the park. Based upon this evidence, it is your duty to answer the first issue, whether the decedent was injured at Jumbo Amusements. No. However, if you happen to find the decedent was injured at Jumbo Amusements, you must continue to the second issue of this case, whether or not Ms. Thurmond was negligent and proximately caused the decedent's injuries. The court will tell you a business owner is not negligent if she takes reasonable steps to ensure the safety of her business. Ms. Thurmond retained guards from the most respected security company in Myrtle Beach. She insisted that her demolition crew install an 8-foot fence surrounding the park, a fence exceeding building code requirements, and she installed a security time clock system throughout her park. The court will tell you proximate cause is the direct cause of an injury. It requires proof that the injury sustained was reasonably foreseeable and that the injury would not have occurred but for the defendant's negligence. Was it reasonably foreseeable that people would climb a roller coaster? Roller coasters are made for riding, not for climbing, and your inquiry should go no further than this issue. However, if you find my client was partially negligent, you must look at the final issue of this case, whether the decedent's own negligence was a proximate cause of his injury. On this issue, the court will instruct you to apply your common sense and everyday experience to the evidence. Now, what does your common sense tell you about climbing a roller coaster? And what does your everyday experience tell you about breaking into a closed down, locked up, and partially demolished amusement park? The fact is, but for the decedent breaking and entering and trespassing on private property at 11:30 at night, this incident would not have occurred. But for the decedent, the underage decedent, drinking himself drunk, this would not have occurred. But for the decedent climbing up the side of a roller coaster, this would not have occurred. But for every choice Tom Calhoun made on October 31st, 1998, this would not have occurred. The decisions the decedent made on that evening leave you with only one decision you can make today. Tom Calhoun did not fall victim to a roller coaster or a ghost. No matter what his age, 60 or 16, he fell victim to his own choices. Thank you.
Oh, Your Honor, before I begin, if I were permitted to object, I would object to counsel's statement that Robin said he fell from a 90-foot roller coaster, as all testimony about 90 feet was stricken from the record.
So noted.
Thank you.
All right, ladies and gentlemen, I want to do one thing that I have always done every time I've tried one of these, and I've got to do it now because I think we always need to do this. Usually every time I try one of these, I always ask the teacher and attorney coaches to stand and be recognized. I will ask that every teacher and attorney coach here for any team, please stand. We want to recognize you.
Same to you. Absolutely. I tell you what, we're going to cheer against you for the next down. But if we lose, we can lose to nicer ones at first. Wonderful display.
Everybody, I need your attention, please. It'll be like the Academy Awards and graduation all at the same time. Most effective witnesses were Joshua Fields, and another Joshua Seidel. Attorneys were Katrina Miller and Ryan Purcell. From Wisconsin. And now, ladies and gentlemen, may I have your attention, please? They came from a long way to win this championship. And what makes it even more sweet is that their coach is retiring this year. Happy birthday to the
has been mock trial coach for a good while, and he's been to several nationals. He and I exchanged a lot of emails over the course of this year, commenting about the problem and how many national cases he's done and this kind of stuff, and he's been around a long time. It's sort of gratifying to see somebody who's been there and worked with kids and has perennially brought them to nationals and done a good job to go out on a note as a national champion.
I'd say the thing about Mr. Nagel is that he's not coaching from the sidelines. He teaches us to help coach ourselves, and that's one thing is that we don't. By the time we're getting closer to our trials, he doesn't need to be there nitpicking at what we're doing because he's taught us to think for ourselves.
He does it so much. It's not even necessarily like his feedback, it's his support. It's his ability to teach people how to think on their feet that I think sets Franklin above the rest, is that he comes into it with such a passion, and he has for so long, that you makes you feel so good about what you're doing and make you feel so confident about it all that you really don't ever work.
Nagel does, it's incredible how much support he gives you because, I mean, like with the closing argument, which is what I've delivered the last 2 years, I always start off by, I think about how I would like to make it sound good, like kind of a LA law type thing is what I like. And Mr. Nagel is always there to say, well, that's good to make it sound good, but first you better get all the law in and you better get all the facts in. So he says, cut this junk out, this theme that sounds good but doesn't mean anything. And so he makes me keep rewriting it until I've gotten the substance in. And then he lets us have our own style. He's never been one to critique our style. He just makes sure it's all accurate and efficient, and we get to choose our style and how we want to present it.
Yeah, I remember when he was trying to recruit me, and I didn't want to do it because I was trying to play basketball at the time. But then after I kind of shied away from basketball, I came to him. I was able to get on the team, and that while he was on the team, he really took another role as a teacher. Like when I had him in class, he's like they said, he teaches you think on your feet. And he supports you. Like if you're wrong, he'll tell you you're wrong, and let's shape it up, and let's get it right for competition. And he's not even like real mean with it or anything. It's just the way he talks to you and the way yourself that I have to get this together because I don't want to let any of my teammates down. And that's
the crazy thing. That just reminded I never ever really thought of Mr. Nagel as a teacher. I forget that he is our coach. He just seems like the guy that's with you, and he's just, that cool guy that is around who just happens to be 3 times your age.
Just happens to know what he's talking about.
Who just happens to know what he's talking about. But I've never really thought of him as a teacher, because he's more than that.
Timekeeper of the Washington team, Eric Chan.
This is a victory that truly had many fathers and mothers.